These are some frequently asked questions regarding what are called Governor's Reorganization Plans or GRPs. So, what is a Governor's Reorganization Authority? The California Constitution grants our governor, subject to approval by the legislature, with the authority to assign and reorganize functions among executive officers and agencies and their employees. So, what's the name of this specific authority? The reorganization of the executive branch of government is called a Governor's Reorganization Plan, more commonly known as a GRP. Now, the GRP cannot affect the other constitutional offices. Is a GRP in the form of a bill or a resolution? Article 5, Section 6 of our state constitution authorizes a statute, hence it begins with a bill, to allow the governor to reorganize functions among state agencies other than those of the remaining constitutional offices. So a GRP is a bill that is submitted to the legislature for approval. What must occur before the GRP is submitted to the legislature? It first has to be considered by the Little Hoover Commission, and that must occur at least 30 days prior to the GRP's submission to the legislature. Where is the Little Hoover Commission authority found? The Little Hoover Commission's role is set forth in California Government Code Section 8523. This was put into California state statute in 1974 by Chapter 1242. What must the Little Hoover Commission do with the governor's reorganization plan? It's required to review the GRP and hold public hearings on the proposal. Thereafter, the Little Hoover Commission offers a recommendation to the legislature to either allow the GRP to go into effect or to reject the GRP. Now, what does the legislature have to do after the Little Hoover Commission recommendation? Well, each house of the legislature has 60 calendar days to act on the GRP bill. The GRP takes effect on the 61st day after submission to the legislature, unless a resolution rejecting the GRP is adopted by both the Senate and Assembly by a majority vote of each house. Is the GRP treated like a bill in the legislature? Yes. Again, prior to transmittal of a GRP to the Little Hoover Commission, the governor submits each GRP to the Office of Legislative Counsel in order that it may be drafted and submitted to the legislature in the form and by way of language that's suitable for enactment as a statute. And the Office of Legislative Counsel also prepares a digest of the GRP. What does the GRP have to be, or when does it have to be submitted to the legislature? While a GRP may be delivered to the legislature at any time during a regular session, it does have to be provided to the legislature so that at least 60 calendar days of a continuous session remain to consider the GRP. And finally, when was the last GRP enacted? If my research is correct, the last GRP was done in 2012 under then Governor Jerry Brown to restructure a number of agencies and departments that were under his authority and control.